I'm going to just talk about the old approach. So for those of you who are not sure, apologies. For those of you who know everything about highways, I just want to touch on the old approach so we can see what the difference is going to be. The well-managed highway infrastructure, the code, obviously that's what we're here to talk about today. Comparisons, are there any differences? Let's have a look at that. The big thing for us as insurers is disclosure and claims handling. And go back to something you mentioned about inspections. I'll sort of be touching upon where we might be with inspections in relation to that, and also the wider impact on claims handling. So we all know that it's section 41 and 58 are the two areas that we look at as insurers for defending the claim. Section 41, your duty to maintain as an authority. And then section 58, my favourite, we've got a defence if we've got a good inspection regime and we can provide the evidence that shows we've done what we said we were going to do. What's assessed? Well, it's pretty obvious really, and you probably all know this. Maintenance appropriate for the highway and the character of the road. The state in which a reasonable person, for those of you who know about insurance claims in detail, we're always looking at what's reasonable. If you're looking at the definition of negligence, it is what a reasonable person would do or would not do, or were there any reasonable omissions. So reasonableness is quite key when it comes to insurance claims. And also suitable warning of a defect. So going back to your inspection regimes, you know, have you got the inspection regimes in place? Also complaints, how do you deal with them? What's your process in relation to getting out if you hear about a complaint, etc. So in the old days, back in the day, we always looked at these three cases from the 60s, all Liverpool Corporation cases, which are still good law today. I've got a couple of football teams up there. There's a really good team in blue. And then there's another team in red. I think it's Accrington Stanley, I'm not really sure. I know, as my daughter pointed out to me when I was putting this together late last night, she said there's only 4 goals difference between the two teams. One is they let 4 goals in at the weekend and the other one they scored 4. Thanks very much. I happen to be an Everton supporter as it happens. But anyway, going back to these three, that's what we used to hang our hat on in terms of looking at defects. And I think that flows down into when authorities are looking at their asset and looking at the road, they're considering, is it 20 millimetres on the footpath? Is it 40 millimetres on the road surface? It does vary according to authorities. Some authorities will do 25 millimetres. Some will do 50 millimetres. With you guys, I know we've got Gloucester. I think you're 40 mil on the road and 20 mil on the footpath, because I know you guys. Are you the same? Generally speaking, that's what, as things stand at present, that's what most authorities are looking at. I did a presentation for the London boroughs a couple of months ago, just before Christmas, and some of them were different. They were 50 and 25, but generally speaking, there's not a lot of difference between the two. So now we have the new code of practice. So eloquently put forward by Steve. Thanks, Steve. Risk-based approach. So from your perspective, I know that's what you're looking into, but from an insurance company's point of view, what is that actually going to mean? So for me, and having spoken to some of my colleagues in claims, it's about, at the end of the day, what is your highway inspector going to be doing when he's out inspecting the road? What is he looking for? And we would expect the code to flow down from the top of the organisation right through. Steve mentioned about data. We're all about data these days, but I can tell you how important that would be in relation to our claims bit, because we've now gone from an intervention level to an investigation level. So what does that mean? So from the highway inspectors, when I used to go and interview the highway inspectors back in the day, they don't be dead simple. I'm looking for a defect that looks about 20 millimetres in depth or width or whatever on the footpath. I'm looking for 40 mil on the road. Is that going to change? You know, at the end of the day, inspectors aren't going to have that guideline set in stone under the new code. They're going to have to go out and look at a road and go, is that dangerous? Do I need to repair that? And going back to Steve's point, the parameters might be in our favour. On the other hand, I suspect claimant solicitors will try and prove the other way around. But that's just something we're going to have to look at as time goes on. Having said all that, is it such a different approach to some of the cases that we've had in the past? Mills v Barnsley, there was a defect that was greater than 1 inch, but guess what? When they looked at the photographs, they decided, do you know what? We don't think it's dangerous. Therefore, went in favour of the defendant and not the claimant. The Rochester Cathedral case, did the defect present a real danger more than every risk pedestrians face from normal blemishes? Again, looking at that, they thought, no, actually, it looks okay. It's not a defect, therefore, why should we pay the claimant? William v Knowsley was more about documents and the quality of the inspections. The Nottinghamshire case, the same defect may be seen dangerous in one area and not another. So, for example, you could have a defect in front of an elderly residential home, or maybe where disabled people use. You might look at an inspection cover, if I was an inspector, and it's maybe only 16 mil protruding above the ground. But given the location of it, is it more than likely there are going to be more people tripping over that than not? Do I need to repair it? Now, maybe that's the sort of thing the guys on the ground are going to have to start considering. And then you did touch upon it, Steve, the Crawley v Barnsley Metropolitan Council. This is the one where the inspection was done on, or the defect was noted on the Friday, and they decided to wait until the Monday to get the repairs done. And I've got a similar case that I'll talk about at the end that's kind of similar to that. Quite harsh decision in some respects, maybe. I think it was a jogger that was going along. It was a jogger that broke their leg or something. And then the thing was, why didn't you repair it over the weekend? And I had a lot of authorities contacting me at the time saying, does this mean we all got to start working at the weekends? And I went, well, the chances of this happening again, it could happen again, but it's not going to be that likely. But it is something you've got to consider. And we've got a case at the end that went to court for Bristol Council, which I'll talk about, which perhaps, maybe it is something to consider for the future. But for me, maybe if you've got something in place in terms of documentation, going back to your data, if you can prove why you do what you do, again, there might be a chance of defending the claims. So here's the big thing for us. It's disclosure and the Ministry of Justice reforms. I don't know how many of you are familiar with the MOJ and the personal injury claims process. I know some of the local authority guys will be. But for those of you not in the audience, I know the majority of claims that I see in my area for the likes of, I've got quite a rural area, or southwest and Wales, we do get an awful lot of accidents involving cars, people driving their BMW over a pothole, damaging their tyres, and that's the most volume of claims that we see in my particular area. I'm imagining it's pretty similar in your neck of the woods. But when it comes to cost and expense, then it's down to personal injury claims. They're the ones that cost authorities and us the most money. Because once you get an injury, then you're talking larger bucks. The MOJ is for claims under £25,000. For those of you who don't know, let's just say Brian had an accident on the footway, he trips over a pothole, breaks his ankle. What does he do? Goes to a no-win, no-fee solicitor, doesn't cost him a penny, puts a claim in. The solicitors say, right, who are the insurers of the authority? They can write to the authority and they can ask for the insurer's details, or they can look on the website if you're an authority that's got the insurance details on the website. And then they have to put the claim through a portal. Now, the portal has been in since 2013. When I first heard that there was going to be a portal in claims, I got quite excited. I'm a bit of a Marvel Avengers fan, and I thought there's a portal in that and everything's great. It's just a drop-down menu. You go onto a website and you're basically filling out a claim form on the drop-downs. And that gets pinged through to the insurers. So that will get pinged through to Zurich. We've got 24 hours to acknowledge it and only 40 working days to make the investigation. So bearing in mind, prior to 2013, for those in the know, we had 90 days to investigate, say, a highways tripping accident. We've now only got 40 working days. And the thing for our perspective is, how are we going to get all the documentation we need under the new code within that 40 working days? Because at the end of the 40 working days, we have to make a decision on whether we're going to pay Brian's claim. So not whether we settle it, but whether we pay it. And that's obviously going to be a challenge. At the moment, disclosure should not be a fishing exercise for claimants, but it sometimes is. They'll try and ask for as much information as possible to see if they think they've got a claim. This on the other side of the slide is the highway tripping claims list that we often get sent to us through the portal. asking for inspection records. I mean, when I used to investigate, I used to go into a council, they used to print off the inspection records, would say, inspection 24th of June, Cheriton Drive, etc., etc. Might be outside number 42, lamppost or something like that. It would have date of inspection and the date of repair. And I used to be able to send that off with a letter to the other side saying, we're defending liability based on this. How things have changed. Now you've now got to send in your inspection records, reasons, but you've got to send a copy of the code, you've got to send your repair records, you've got to send lots of other things. So even as we stand at the moment, there's a lot more documentation that's got to be sent to the other side, especially if we're going to defend something like Brian's claim, to show that, do you know what, we've done what we can to defend this claim. So under the new code, here's where it's going to get, I wouldn't say complicated, but different. So it's going to see a significant increase in the volume of documentation that we need. Other things that we're now going to be asked to look for, we reckon, are going to be published highways policy, that goes without saying. The risk assessments now. So you've got an inspection regime, but where's your risk assessments? Accident statistics. You know, that's a bit of a pain or a ball ache, as somebody said earlier on, apologies, but yeah, there can be, trying to get accident statistics. You might be coming to your insurers for that. Do we have everything? If you're handling your own claims in-house to a point, so say you're handling your own third-party damage claims, are you going to be able to supply our statistics and their statistics? How do you get that together? Bearing in mind we've got 40 working days to do all this, if it's an injury claim. Evidence of decision making, inspectors' training records. Steve alluded to that in terms of training. I think that's going to be very important going forward. Once this is embedded, we're certainly going to have the inspectors trained up on things. I was speaking to a local authority in South Wales and talking to a couple of inspectors, and they're just like, oh, I can't be bothered. I'm just going to look for 20 mil and 40 mil. I'm not going to tell anyone, like, but as far as I'm concerned, I've always done it that way, and I'm not going to do it. Excuse the accent. And that's the way they'll look at. They'll still go back to. They want to default back to what the old style was because it's easier. But if you think in the long term, you are looking at. Just look at the area. You've been trained. Maybe you don't need to repair it because it's 20 mil. So that's something that we're going to have to deal with as and when we go forward. I've got a couple of notes here from some of our claims handlers in our head office. Is that, you know, when they ask for information, the claimant solicitors, what are they looking to resolve at the end of the day? If you've sent them the inspection records and you're saying we've got a Section 58 defence, if they want more information, what exactly are they asking for? Do the documentation they've requested assist in dealing with the claim? You know, we get a lot of spurious documentation requests from solicitors saying we need this and we need that. I just think we need to be more robust as well, in conjunction with you guys, and say, do we need that? Do we really need to go back and have that? You know, what's that documentation for? It doesn't prove anything. So, you know, as I said, this is one of the challenges we're going to face. Other sort of areas to look at is, can we evidence that the local authority has got the maintenance plan and they can do it? It's all down to the evidence at the end of the day. What's the strategic decision? Can we evidence that that we've got the risk-based approach in place and that our plan reflects that risk-based approach? I mean, that's, you know, when you say that to a highway inspector, he's like, oh, bloody hell, I need a drink. Off he goes. But you know what? If the hierarchy, the people from the top have got it right, going back, I think, to your point about getting it right, or getting the right data, that should be easy to go back to and refer to and say, well, actually, this is how we're doing it. We'll be able to support decisions based on the risk assessments. So again, we've got the inspection records, but the risk assessments, do they help support us in that respect in terms of turning the claim down? And have inspectors registered on the register of highway inspectors. I know a lot of highway inspectors around the country have been employed for a long time. What are their qualifications? Are they registered, etc.? That's the sort of thing we think they'll be looking for. And something else that was alluded to earlier is this more interdepartmental documentation, I don't know, collaboration, I suppose. I would imagine that where we just go to highways and then go to the maintenance and the roadworks guys, we're going to have to go to other departments in the authority to get more information. And I'll just see how the courts will sort of react to that sort of thing. We think, if I was a claimant solicitor, I would be looking to pick holes in all the documentation you send us with the new risk-based approach. Because under the old system, you had that 20 mil, 40 mil, look, there's our intervention levels. Now we've got the investigation level. If I was a claimant solicitor, I'd be going, oh, what about this? I'm sure you'll have a health and safety minute somewhere, and I don't know, somebody might have spoken to someone else and said, oh, I hear such and such counsel are struggling with this, that and the other. And the claimant solicitors could then be saying, oh, I want minutes of the meeting that was referred to by such and such and such. Well, they start trawling your websites if you're a local authority and saying, like, well, let's look at what they've got about the risk-based approach and maintenance and start using them against a reason why they're trying to solve. I mean, claimant solicitors, we all know, will look for any reason for their claim to be successful, and they'll just try and pull apart any defence that we put forward. We've talked about resource, and is resource going to be an issue in the future? I don't know what you think, Steve, but I think the courts are going to have to accept that sometimes resource is going to be an issue. I mean, we've got the Wilkinson and York case that those of you may be familiar with, where the cyclist went over and York said they changed their inspection regimes, etc., and it was to do with the lack of resources to be able to do what they used to do. Now, if you're going to change your inspection regimes, are you going to be able to say, well, actually, we've only got a finite amount of budget, we're doing this? Again, I think it's all down to, from the top, if you can evidence how that's come to that and why you've made those decisions, we've got a much better chance of defending the claim. I mean, if you had a road that you inspect once a year, for example, and you decide you look at it and so on, this is costing us money, but guess what? We're only repairing it. If you expected it maybe 3 times a year, but you're only repairing it once a year, do you, under the risk-based approach, look at it and say, actually, we only need to inspect this once a year because that's the only time we ever repair it. It's very rare that repairs, or defects materialise on it. So you could change an inspection regime, but as long as you've evidenced it and you've got the data behind it and the documentation, there could be a reasonable chance of defending it. On the other hand, if I'm a claimant solicitor, I'm going to try and turn that around and said, you've obviously got a problem because you're reducing the number of inspections. And I do think at the moment, as we stand, that we haven't got a defence to resource. I just wonder, going forward, because we've got the new risk-based approach and austerity and all the other things. I mean, nobody seems to be making more money, do they? I mean, just Carillion have just got into difficulty, etc. So will judges have to at some point accept, okay, there's a finite amount of resources? But you're right, as things stand at the moment, we haven't got a leg to stand on. You cannot say lack of resources or lack of people. Funny enough, I did some work with one of our local authorities in South Wales, and the defensibility rate was pretty poor. It was around about 60%. Most of you guys, hopefully, you should be up there in the 80s, 90% in relation to defending claims. And one of the issues they had, where they had a lack of resource in the inspectors. A couple of guys were off sick, 2 guys had left, and they hadn't replaced them. And because they were going under a restructure, they wouldn't change things. But going back to Steve's talking about talking to insurers, please talk to us when you've got scenarios like that. So what I managed to do is get in to see the highways management. So I usually, when I just deal with the insurance people in an organisation, got beyond that into the highways guys, sat with them and managed to persuade them that they needed to change it. They asked me to write to their managers themselves, so I had to go further up the authority and wrote a strongly worded letter in relation to, you need to do something, otherwise it's going to cost you a fortune on your highway claims. Fortunately, they listened. And they actually employed 2 new inspectors and stuck another £500,000 in the budget towards highways. So, if you think you've got a problem and your insurers, you think, we just send the claims off, come to us and have a chat with us, because you just don't know whether we can get involved and help you make a difference at your level. Funny enough, it's something we're just talking on the table by here about cross-collaboration between authorities. What's your neighbouring authority doing? If your neighbour authority is using ABC and they've got a similar road network and that's deemed to be a better system, then you're going to be considered flawed by default. So you need to talk to your neighbouring authorities and make sure that you're all singing from the same hymn sheet. Onto this relation into searching for flaws and discrepancies. Does everyone know what a PAD is? It's called a pre-action disclosure, right? I know you know what it means. It's a pre-action disclosure. So essentially, going back to what we were talking about there, 40 days, say it was an injury claim, and we're waiting for the information to come through. Say we don't get the information on time. We don't get all the documentation on time. It will drop out of this portal that I talked about on the website. It drops out the portal. And we don't want it to drop out of the portal if we're going to pay the claim, because we need to keep it in there for fixed costs. If anybody wants to talk to me about that later, I'll expand on it, but I'm assuming quite a few of you understand the process. But it drops out the portal, and the next thing you know, the claimant solicitors will issue a pre-action disclosure, which is a mini summons, basically forcing you to go to court to supply the documents that they've asked for. And a lot of the time, some of the information they've asked for is not relevant. And so we think there's going to be a lot more pre-action disclosures coming out. So going back to your point about solicitors making a little bit of money, you could have two pre-action disclosures on one claim. We've actually got our costs down, actually, in accordance with the Leeds County Court case, to £405 for every pre-action disclosure that's issued. Because when somebody issues one of these pre-action disclosures, technically we're supposed to instruct the solicitor and go to court and say, we're still trying to get the documents, or actually we've got them here now and we can supply them. But you don't want to go through that cost. So sometimes what you've got to do is just say, put the judgment aside, we'll agree to pay your costs. We are looking for the documents you're on about, and we've agreed £405. But we've got claims history for some authorities where they're looking at, you've paid out £405 on this claim, but we denied liability afterwards. It's because we had a pre-action disclosure. I mean, sometimes it might be insurers that have cocked up and not got the information off to the other side as well. So it's not just you, but I think pre-action disclosures, unfortunately, we're going to see more of going forward. The one thing that you touched on as well, Steve, was training. I think that's going to be paramount now in relation to especially the highway inspectors. From our perspective, if we can help in that regard, please let us know. And storage, I think most authorities are going down the electronic route, but if anybody is still paper-based, and where are you going to put all this documentation? Where's it all going to go? I mean, that's just something else you've got to consider. I mentioned the need for training, mindset and culture, that's got to change. I think Steve alluded to that in relation to his earlier presentation, and going back to when I'm talking to my mates in West Wales and they're going, I don't want to do that. Essentially, they're going to have to change it. This is the future. They're going to have to change the way they look at things, and that's going to be a challenge for us. I mean, the good thing is increased flexibility. Maybe I'm a glass half kind of full kind of guy, so maybe for me, this risk-based approach might be a good thing. It might help us defend more claims. That's the way we're hoping it's going to happen. So that's a kind of brief overview of where we are in terms of documentation, etc. Does everybody understand the claims process? Does anybody need me to explain more about what happens? Is everybody quite right? Everyone seems okay with that. If you need any I think we've got questions afterwards, and also I'm around at lunchtime, so if you want to have a chat with me then. But I just want to talk about a couple of cases because I thought they'd be relevant. So this was a case involving a South Wales council. Claimant tripped over a pothole that was in excess of 20 millimetres on the road, not on the footpath, on the road. The actual area was not a zebra crossing, but it was deemed a crossing point by some people. So a lot of people used it to cross the road. So essentially, we defended it based on our Section 58 defence. We turned around and we said this, whatever, but it had been noted at the previous inspection that the defect was more than 20 mil. So we defended it on inspection, Section 58, and on the basis that it wasn't 40 mil, and our intervention level or investigation level was 40 millimetres. And we denied liability. The claimant solicitors didn't accept it, and we ended up going to trial. What do you think the outcome was? Hands up those who think we were successful in defending it. Oh, that's good. I know you lot are thinking the same, really. Come on. We weren't. We lost it. We lost it on the basis, and this is where I think the risk-based approach might have come in handy, is because it was on a crossing point, even though it wasn't a designated crossing point. And I think by the letter of the law, we took this to trial because we thought we had a good case. So we don't take cases to trial unless we think we've got a reasonable chance of defending it, because of those of you who know, who've been in a court of law, sometimes it's a lottery and it can depend on whether the judge likes you or not. But we thought we had a good case on this, and they said no. You knew that people crossed in that area, so you should have looked at the 20 mil intervention level rather than the 40 mil. So that's a case that, you know, even I got asked about this as the claim service manager for the local authority, and I said, yeah, let's run it. And we knew there's a danger, and we lost it. But under the new code, would the inspector go, guess what? There's lots of people crossing there. I think we'll put a repair in. It's just something for you guys to think about, you know, as we go forward. And this is another one that's fairly recent, and I can actually name the council because it's out there on the internet, so it's not something we don't know about. So we've got the claimant driving his Audi R6 to Bristol Airport with his pregnant wife in the passenger seat, and apparently he's driving over what is Cabot Way in Bristol, which is a fairly straight section of road. I've got a dodgy photograph which I'll put on in a minute. And he sees some debris in the road, and he goes, oh, hang on, and he swerves to avoid it. And as he swerves to avoid the debris, he hits this pothole, his tyre bursts, etc. So they went out to have a look at it. The defect was alleged to have been 500 mil diameter and 40 millimetres in depth. But it turned out that the day before, on a drive-by inspection, hence, no, I say drive-by inspection, I'll come on to that in a minute, one of the inspectors spotted it and said, oh, we need to get that repaired, okay, because in his view it was just about on 40 mil. They arranged for the repairs to be done on Saturday. So going back to the Crawley the case we talked about in relation to should you have teams working on Saturday, well, guess what Bristol Council do, and they arranged for it to be repaired on a Saturday. The claimant, we therefore turned the claim down and said, and I know it's not an injury claim, so the portal doesn't apply, even though there was mention of the lady who was pregnant suffering a few bits and pieces, but they hadn't put an official injury claim in. So we turned the claim down on the basis that, well, actually, we think that's more than reasonable. We've inspected the area, we've spotted the defect, and you know, we've complied with their Section 58 defence. Can you just about see that there? This is the defect here, fairly straight section of road. There was no sign of the debris when our inspector looked up there, but we can't say there wasn't, you know, oh, there wasn't any debris, you shouldn't have swerved. That's a fairly, I think you'd agree, it's a fairly substantial pothole. Anyway, we went to trial on this one. How do you think we fared?
I know I'm for Bristol City Council.
Sorry?
I know I'm for Bristol City Council.
Oh, right, okay. Do you want to tell them what happened?
We lost, and the reason we lost is because the pothole was 18 mil deep.
But I'd still argue, what had we done wrong? We'd identified it, whether it was 40 mil or 80 mil, and this is sometimes happens when you go into a court, the judge will hang his hat on something that you wouldn't have thought of. Because you'll think, okay, that's 40 mil or 80 mil, it's still a defect that we've got out and repaired within a couple of days. What else were we supposed to do? The other thing that I don't know if it was mentioned in court is that drive-by inspections generally are difficult to defend. So there is case law to show that if you're on your own as a highway inspector, driving a rural road inspecting, great that you can pick up some defects, and if that's your system, that's your system. But don't ask me to come and defend it in court, because it ain't going to happen. Because the judge will just say, how can you look at the road and drive at the same time? It's not going to happen. And the thing is, again, if it's a risk-based approach, would you have done that any differently? You know, would you have got it repaired straight away? Would you have done it immediately? Do you look at it and think, I don't know, if it's raining, is it going to get worse? Maybe it was 40 mil when they looked at it, and then it was 80 mil later. We don't know. You know, again, from a risk-based approach, would you do anything different? I was going to talk about the coroner's inquest and the cyclist, but Steve stole my thunder on that and mentioned it already. So I'm not going to go into detail on that. But again, the council still operated under the old code, and going forward, are they going to change it? They say they will, because you know we're looking at the new code and that's going to be implemented. So summary in terms of evidence for us, honestly, we you know cannot be overstated. The data that Steve's mentioned, we need that if we're going to defend the claims. The claimant's mantra will always be, if you haven't, if there's no evidence, it didn't happen. We didn't look at it. Yes, we did. Well, where's your evidence? And court decisions, well, there's some uncertainty, and we're just going to have to wait and see. It may well be we're going to have to take a few cases to trial under the new code and see where their land lies on them.